What's up, everybody? I'm back and I'm continuing to go over the state's response to Kathleen Zellner's latest filing on behalf of Stephen Avery. I will link all of the other parts of these videos in the description below so you can get caught up if you like. We're going to continue right where we left off. The defendant further failed to offer any facts of record that established a consistent plan to frame the defendant or any theory, including or excluding law enforcement involvement which implicates the defendant in this crime. The defendant's theory that Bobby framed him for this murder also fails to acknowledge a significant fact in relation to this crime to which Brendan Dassey confessed and was convicted of participating in the murder of Teresa Halbach. Brendan specifically implicated the defendant in this crime, and his conviction has been affirmed by the appellate court and remains of record. All of the allegations implicating Bobby in the murder and framing of the defendant are pure speculation and not supported by any evidence submitted by the defendant. As such, the defendant failed to meet the tests in Edmonds, Denny, and Wilson. Finally, the defendant asserts that the Sawinski affidavit supplies a direct connection between Bobby and the murder of Teresa Halbach. The defendant asserts that because Bobby was in possession of the victim's RAV4, it proves that he had access to the key to the defendant's car and her electronics that were found in the burn pit. The items are links that are central to proving Bobby Dassey's involvement in the murder of Teresa Halbach. The defendant argues that Bobby's possession of the car provides a direct evidentiary link between Bobby and the crime committed, making him a viable third-party suspect. Assuming for the purpose of this motion that everything in the Sawinski affidavit is true, the defendant is incorrect in his assertion that the facts in the affidavit provide a direct link between Bobby and the murder of Teresa Halbach. The defendant asserts that if Bobby was in possession of the victim's car that night, he must have also been the individual who committed the murder. No evidence submitted by the defendant supports this conclusion. Even if Bobby was found in possession of the victim's automobile on the night of November 5th, there is only speculation and no evidence to prove that Bobby was in possession of the car or that he had exclusive control over the vehicle prior to that night. The defendant further asserts that Bobby's possession of the car gave him access to the victim's key and her personal electronics. Again, this is speculation by the defendant. Mr. Sawinski's affidavit does not mention seeing Bobby Dassey with the key to the victim's car. In fact, the affidavit establishes that Bobby was pushing the victim's car without power on the night in question, placing doubt on whether he was in possession of the victim's car key. The affidavit does not mention that Mr. Sawinski saw Bobby with the defendant's personal electronics. There is no evidence that those items were in the car at the only time it was linked to Bobby Dassey by Thomas Sawinski. Neither the key or the electronics were linked by any witnesses or by any forensic evidence to Bobby. The victim's keys and electronics could have been taken directly from the victim or taken from her car at any time prior to or after the murder by another individual, long before the automobile was in Bobby's possession. There is no evidence of record taken from the car that links Bobby directly to the actual homicide of Teresa Halbach. The Sawinski affidavit, taken as true for the purpose of this motion, directly links Bobby to possession of the victim's vehicle. However, possession of the vehicle does not directly link Bobby to the murder itself. Nothing in the affidavit establishes Bobby was in possession of the evidence that the defendant asserts was used to frame the defendant. No forensic evidence was found in the car that directly linked Bobby to the murder. No evidence of record that establishes that Bobby had exclusive possession of the victim's vehicle prior to the night that Thomas Sawinski saw him on the road, or Bobby had any control over the vehicle prior to that date. None of the physical evidence presented at trial links Bobby Dassey to the actual commission of the homicide in this case. While the defendant asserts that the only logical conclusion can be drawn from Bobby's possession of the vehicle that night is that Bobby was the individual who actually killed Teresa Halbach, this assumption is flawed. The other reasons that Bobby could have been in possession of the car that night, including Bobby was trying to help hide evidence to protect the two individuals directly linked by forensic evidence to this murder and convicted of the crime. The defendant's conclusion The defendant's assumptions drawn from the evidence offered in the affidavit do not amount to evidence directly linking Bobby to the homicide itself. As such, the defendant failed to meet the final standard of the Denny test to establish Bobby as a valid third-party suspect in this crime. The defendant also alleges that the state committed a Brady violation by failing to turn over the record of the phone call that Mr. Sawinski made to the Manitowoc County Sheriff's Department in 2005. The defendant accurately summed up the requirements for the finding of a Brady violation. With respect to the second and third prongs of the Brady test, the court addressed whether the evidence was favorable to the defendant for the purpose that it was offered and whether it was material to an issue at trial. It concluded that the evidence did not meet either of those criteria. As such, the defendant failed to establish a Brady violation with respect to the Sawinski evidence. With respect to the statement of Kevin Romlo cited in his brief, the defendant notes in paragraph 118 that this statement was submitted to the court in its motion to reconsider in October of 2017, denying his second post-conviction motion. The defendant asserts that his claims should not be procedurally barred under the state ruling in State versus ESCALONA-NARANJO because the court did not specifically address the affidavit in its ruling on the motion. While the court did not specifically address every document or exhibit attached to the motion, the defendant, in its October 2017 ruling, the court considered each filing in full. However, to be clear, the court will specifically rule on Kevin's affidavit with respect to the defendant's current motion. A Brady violation occurs when the prosecution withholds evidence that is favorable and material to an issue in the case. A Brady violation does not occur when the prosecution fails to turn over the type of information that could form a bias for further investigation by the defense. With respect to the defendant's theory that Bobby Dassey is a credible third-party suspect, Kevin's affidavit falls into the category of that which could form bias for further investigation by the defense. Putting aside any credibility issues on the part of the affidavit, if taken as true for the purposes of this motion, establishes that the victim's RAV4 was away from the Avery property between the time of the murder and the time it was discovered on the Avery property. As discussed previously, there is nothing in any of the exhibits offered by the defendant that establishes Bobby Dassey had possession of the vehicle any time before the night that Thomas Sawinski states he saw Mr. Dassey with it. Noting that in the affidavit, Kevin directly links Bobby to the vehicle at the time it was observed by him. Mr. Sawinski's affidavit only asserts that he saw Bobby pushing the car after Kevin saw it parked in a different location. There is no exhibit offered that establishes that Bobby had the key to the victim's vehicle. While Kevin's information may have been an avenue for further investigation, the exhibits submitted do not directly connect Bobby Dassey to the homicide itself and fail to meet the standard under Denny to establish Bobby as a third-party suspect with respect to the crime. As such, the failure of law enforcement to turn over Kevin's statement is not a violation of his constitutional rights as defined in the ruling in Brady. On May 26, 2023, the defendant asked the court to consider another affidavit from Tom Burrish. In that affidavit, Mr. Burrish states that on the night of November 4th or the early morning of November 5th, he was performing his duties as a tow truck driver when he observed Bobby Dassey driving a RAV4 on County Road Q. Mr. Burrish states that the headlights from the truck lit up the interior of the RAV4 and he could clearly see Mr. Dassey and someone that was not the defendant in the vehicle. The affiant goes on to state that while he was incarcerated for bail jumping in 2006, he reported his story to a Brown County Sheriff's deputy who discounted his report. Mr. Burch then states that he did not discuss what he saw until sometime in 2016 or 2017 when he mentioned it to his brother. The defendant reports that he received his affidavit on May 10th, 2023, but unlike the Sawinski affidavit, it does not provide any information on whether the statements made in the affidavit were verified or the investigation was completed. Once again, for the purposes of the motion, the facts in the Burch affidavit were true. The facts do not directly link Bobby Dassey to the murder of Teresa Halbach. The affidavit asserts that two people were were in the car when it was seen driving down the road. While Mr. Burrish states that he conclusively identified Bobby in the car, he cannot identify the other individual in the car other than to eliminate the person from being the defendant. Once again, the affidavit links Bobby Dassey to being in possession of the RAV4 after the homicide took place. There is nothing in the affidavit that establishes that Bobby had possession or conclusive possession of the vehicle prior to that time. The affiant states that a second individual was in the car at the time he saw it driving down the road. The affidavit does not establish that Bobby was the individual who was in possession of the key to the car or the car itself prior to that night. The affidavit, only taken as true, establishes that Bobby was in possession of the car on November 4th or 5th. However, even by affidavit statements, Bobby was not the only person in the car that night. Nothing in the statement links Bobby Dassey to the homicide itself. One would have to leap to the conclusion that if it were in possession of the RAV4 that night, he must be the individual who committed the murder. As previously discussed, no direct evidence in this matter links Bobby directly to the murder. Furthermore, in this affidavit, a new unnamed individual could equally be implicated as the murderer. In this case, the theory offered by the defendant, the unnamed individual had equal access to the car key on that night in question. The individual could have been the individual who, if the defense theory is correct, could have moved the car back and forth from the property, removed the personal electronics from the car, possessed the key, and then planted it at the defendant's home. As such, affidavit also fails to meet the test in Denny to be admissible to prove existence of a third-party suspect. In alternative to his motions under Denny, the defendant asked the court to grant him a new trial in the interest of justice. Given the above conclusions reached with respect to the evidence offered by the defendant, there is no legal grounds to grant such a request. For the reasons set forth above, the motion of the defendant is denied. So that is the complete 31-page filing. I will link all of the other parts of this video series in the description below. Let me know what you think. Leave some comments below. I hope you're having a good day, and I will see you again soon.